Hello, I am Jim Schaefer, a California family law forensic accountant. I have presented on tracing in a number of live presentations. I hope you will enjoy tracing topics in this animated format. This series of animated presentations is designed to provide insights how family law counsel can overcome problems in tracings. Here are 3 examples of tracing problems. This video will provide some solutions to the not understandable problem. Sometimes I work extremely large cases with multiple forensic accountants. During the course of the case, I frequently hear these words from the other forensics on our team.
The judge will never understand my schedules.
Let us play that back one more time for emphasis.
The judge will never understand my schedules. In fact, judges never do. Judges simply must rely that I know what I'm saying.
I have learned through trial and error to be careful with the next question. Why are the schedules designed so that the judge will not understand? This animation provides potential solutions, starting with counsel's interview of the potential forensic.
The Jones case is a complex direct mechanical tracing case. The tracing will spend 6 years and 30 to 40 accounts. I expect that efforts to settle will fail and we will be presenting the tracing to a court. My first question is, do you design your tracing report and schedules to incorporate good communication techniques so that the court will understand your work?
I am glad you asked that. Most attorneys are not concerned about that. I can do that if that is what you really want.
This interview is going nowhere fast. Instead of continuing, I will discuss the problem, its importance and solutions. It is obvious to most that since family law cases are decided by the judge, it is vitally important that the judge understands the forensics work. Over time I have been a close observer of what judges think. Here are samples from my observations. In 2016 I prepared slides for a family law presentation with Judge Denton as presenter. His powerful theme is shown at your right. I will give you a moment to read for yourself. In 2015 I greatly enjoyed presenting with Justice Sun and Shine. One of her key themes was that accountant reports need to be simple and understandable. To emphasize, she generally told the audience that she hated to tell her husband that she was bringing home yet another forensic accountant to explain their report. In 2008, Judge Thomas Murphy wrote an insightful article for the ACFLS newsletter. He described a case that impressed him. This was a case where the forensic analysis was straightforward. Not only was the analysis in this case understandable, it was comprehensive. I will repeat that. The analysis was understandable and comprehensive. Finally, Judge Murphy explains that this case incorporated what is seldom done in family law cases. The documents in the case were base-stamped so that there was no issue as to what documents were utilized. Concluding this section is a quote from Judge William Howitt as follows: "The expert is a guide helping the court understand a mass of documents and how they support or defend a summary or opinion." You do not need rocket science to fulfill the needs of the only person in the room that really counts, the trier of fact. Rather, counsel needs to supervise the expert on their opinion to be offered and the communication techniques to be used. Communicating your tracing case is a 2-step process. Step 1 is learning the facts. This step is customarily performed in a satisfactory manner. Step 2 is working on how to teach the facts. This is a step either sometimes overlooked, not performed due to time constraints, or not in the encounter's DNA. This is the step where counsel needs to be a close supervisor. To summarize, I think we all agree that in non-jury trials, the judge is the most important person in the room. I have shown you 3 examples of judicial officers who think their understanding of the case is vital. In my experience, most forensic accountants understand step number 1. So let us turn our attention for the balance of this presentation to step number 2. Please forgive me for oversimplifying. In my world as a forensic accountant, there are 2 kinds of information I can present to the court. Number 1, information related to legal elements. Number 2, noise. Providing understandable information concerning the legal elements is my purpose. If I stray off topic and create noise, it can hurt the case. Before the forensic can paint a clear picture, the forensic needs instructions from counsel concerning the legal element to be proved. Here is an example at left. Prove there was no community property dollars for the acquisition of the asset in question, but there were separate property dollars sufficient for the acquisition. So let's go back to interview of counsel and forensic accountant.
In this case, I need to prove 3 elements. Number 1, separate property funds were available at the time of the acquisition. Number 2, separate property funds were actually withdrawn. And number 3, there was intent to acquire as separate. I need you to prove number 1 and number 2. I'm hoping that the facts are that there were sufficient separate property and absolutely zero community property funds at the time of acquisition. If all goes as planned, I expect that you will be able to opine that separate property monies were the only monies in the account to acquire the asset at the time of acquisition.
So you do not want me to simply opine that the Apple stock is your client's separate property?
Okay, let's cut that interview off. Counsel is seeking an opinion that will fit her theory of the case if the facts support. The forensic is on a different freeway. It is the freeway of no understanding. Counsel needs to better explain the role for the forensic accountant. While we are on the topic of naive forensics, let me share one of my early experiences. Early on in my career, I asked a distinguished judicial officer whether it was a good practice to use the technique of quoting my client with the words, "My client told me," and I believe it to be true. I will never forget the reply, which was,
"Jim, if I wanted to know what your client thought, I would put them in the box and ask them myself."
I quickly understood using this quoting your client technique and relying thereon was an approach to be avoided at all costs. In summary, to this point, counsel must clarify with the forensic the opinion being sought so that counsel does not get a less useful opinion at the last moment with no time or dollars to fix. Here is the key to explaining a tracing. I call it the 3-level approach. In preparing the facts, the forensic works in order of 1, 2, and 3. In explaining the facts, the forensic works in order of 3, 2, and 1. Most forensic accountants are familiar with Level 1. Level 1 is generally a schedule showing one bank account at a time and showing one transaction at a time. There are several columns each for account transactions. The tracing schedule also designates transactions for the community, and transactions of each separate party. This is standard stuff, and unfortunately many tracing forensics stop here and simply give the opinion that the asset is separate property. Levels 3 and 2 are generally summary demonstrative exhibits that summarize the facts that were analyzed in Level 1 to develop the forensic accountant's opinion. Let's look at some examples of these demonstratives. At left, I have prepared a high-level summary of the tracing. Such a summary serves as an introduction to what is demonstrated in the hundreds of pages of tracing. At left, I have depicted a Level 2 demonstrative showing more detail than the Level 3 demonstrative. My suggestion is that the forensic add page references to the page number in the Level 1 schedules. For example, if the forensic adds a page 108 to arrow number 2 on this page, it will greatly aid the forensic in giving efficient oral testimony. That is to say, bridging between an arrow in a Level 2 demonstrative and a Level 1 detailed schedule is important. To follow this plan, timing is important. At the beginning, counsel would define the question or legal element. The accountant's report would be completed 2 weeks before filing due date to allow counsel time to review and discuss revisions with the forensic accountant in order to line up with the legal elements assigned. The extra time, in my view, will provide significant rewards in the results of cases. Oftentimes, the most important items to remember are presented first and last. We began this presentation with comments from 4 retired family law judges. We now conclude with thoughts from Judge William Howat, Jr.
Here are my summary thoughts on this topic. A working knowledge of Evidence Code Section 1523D is important. Oral testimony of the content of a writing is not made inadmissible by subdivision A, if the writing consists of numerous accounts or other writings that cannot be examined in court without great loss of time, and the evidence sought from them is only the general result of the whole. Next, know the judge's preference for how the evidence should be presented. Either orally in summary, or with charts and graphs to articulate important transactional history. Also know the preferences for size of the font, charts, and for summaries. Bates numbering is critical to a full understanding to the opinion of the experts. Again, I will repeat for emphasis. Bates numbering is critical. Use a summary page with clear and concise language. The summary page should come at the beginning so that the judge will be alerted to look for the factual support in the explanatory testimony that follows the summary of opinion. If necessary, include an explanation of the steps to reach the conclusions made in the summary. Consider a summary of your opponent's work that can be an effective way to focus the judge's attention on the important issues contained in that work and summarize the failures of the opponent's conclusions.
Let us conclude this presentation with a final interview scene featuring family law counsel and family law forensic accountant.
Frank, thank you for meeting today. I have a potential case I would like to discuss with you. It includes a complex tracing with 30,000 pages of documents. What can you do to help me with this case?
Thank you for considering my services. In short, I would first learn the facts and then work on how to educate the court. Before proceeding to the education part, we would discuss which of the elements you are assigning to me. There are many important aspects like giving the right opinion, Bates number referencing, and knowing the judge's preferences.
So long as you agree that you will complete your work at least 2 weeks before filing deadlines to allow for review and coordination with my work, you are the right forensic for my case.